Thank you. Good afternoon. Francisco Mingorance. I'm here speaking on behalf of a group of European innovators, small and large company. And I have a question for Ms. Renata Hayes from the Department of Justice. The question is the following. The US has a long-standing tradition of protecting and enforcing IP internationally. We can see that every year with the Special 301 report and other similar activity. And my question to Ms. Renata is the following. Did the DOJ, independently or with other US agency, assess the compatibility of the new IEEE rules with regard to US international treaty commitment under the WTO, notably the TBT and the TRIPS? Thank you.
So we considered everything that we needed to consider in order to come to that to the conclusion that the proposed policy changes would not be worthy of antitrust enforcement. So I don't remember a specific discussion of the trade implications, but that really wasn't also the question that we were asked. And since we are a law enforcement agency, we don't tend to consult with other parts of the government on our law enforcement decisions.
Further questions? No questions. That's surprising. Oh, here up in front, the Etsy guy. What can we do for you?
Thank you, Serge, from Orange. I would like to understand what actually, Joseph, you said. Maybe I did got it wrongly, and excuse me if that is the situation. In the you said that a patent assertion entity like CISVEL, and you referred that maybe there exists a different patent or SEP holder behind a PAA, but that, how is that known? Was the question you were asking yourself and ourselves, and my question comes then to, if somebody wants to enforce a patent against somebody else, is that not clear that he has to show the proof in front of the court that he's the owner of the rights before he does that? And hence, how can this situation develop? Your question, I see no ground for this question. Could you please elaborate on that?
Yeah, I'm very happy to do so. Patent assertion entities often advertise their service as the best way to commercialize innovation, and of course to generate most income. So the idea of generating high levels of income is very much part of what patent assertion entities are doing. This is not illegitimate in the first place. But what happens is that then patent owners would transfer the patent. And in Europe, for transferring the patent, you don't have to register it. And in the first place, if you don't get the information on what the patent is, you simply don't know. And what I was describing is the pre-litigation stage. So you get a warning letter in the first place, and if you are a small implementer, you're facing a problem. The question is, of course, you will consult a lawyer, and the lawyer has to inform you. But what do you do with Huawei? If you agree with this reading, that this only applies to firms that are vertically integrated, and so the Huawei rule only applies to this case, you don't know. It might well be that a competitor is actually using a patent assertion entity in order to create a kind of a wall behind which the competitor would hide, because then the implementer will not know that the Huawei rule would actually apply. And this already creates a big issue.
So I see two things: a threat, which is in pre-litigation stage, and the second issue, of course, that will be revealed later on if the case proceeds then to a full litigation in front of a court. And then you need to transfer or register that patent in the name of the one who is actually suing. Okay.
Yes.
And just the last subsequent question. So I think you're describing CISVA as just an example, as a way to, you qualify that patent assertion entity. Is that also applying, in your view, to a patent pooling or patent agent position that sometimes this company, as I know, is actually acting as part of a collective licensing agreement?
Well, there are different terms that are used to a rather big group of entities, and of course, also CISVA would consider itself almost like a pool. CISVA would argue that they are building up interesting patent portfolios, not only in the interest of the owners, but also for the implementers. So the positive effect of the pooling, this is why I'm also very, very cautious to condemn entities like, that's part of the positive effects of what patent assertion entities can actually do. Bring together important innovation and to engage in bundled licensing.
Thank you very much. I think we will have to come to an end so that Professor Belflam at least has some minutes for his concluding remarks.